Hello, this is attorney Noreen Barsana of Barsana Law Offices here in Pasadena, California. You can always reach us at 626-898-7200. And here at Barsana Law, we practice immigration, family law, and criminal defense. So feel free to call us if you have any questions. I'm going to be doing a video today on something called summary dissolution, which is part of family law. Again, these videos are for informational purposes, and if you have more questions, you are welcome to call our office or any attorney. So, what is summary dissolution? Summary dissolution is basically an option for two people who have been married less than 5 years and decide that they no longer want to be married. In order to qualify for summary dissolution, you do have to meet certain requirements, and the reason for this is because the two people, husband and wife, husband and husband, would be filing jointly, and that's together, for divorce. So in order to qualify for summary dissolution, you have to meet all of the requirements that the law says, which is that you have to have been married for less than 5 years. So that means you cannot have been married 5 years. It has to be 4 years and 11 months and whatever amount of days is less than 5 years. And that's from the date you got married to the date you were separated. The two people cannot have any children together, and that's biological or through adoption. As long as you have no children together, you qualify. Neither party can own any part of land or buildings, and you cannot rent any land or buildings except for where you currently live. In the marriage, you and your spouse cannot owe more than $6,000 worth of debt, and that means credit card debt or community obligations. It does not include car loans, so it's more like you have a Macy's bill or you have a bill from American Express. In California, we are a community property state, meaning that when you get married, everything that you and your spouse acquire during the marriage, everything that you and your spouse spend during the marriage is all part of the community, meaning it's part of both of your marriage. And you equally have to split all assets and debts. So that is something you want to be wary of when you enter into marriage. In order to qualify for summary dissolution, you in the marriage, both parties have to have had less than $45,000 worth of property. So that's, again, community property. There also cannot be any separate property that's worth more than $45,000, meaning if you went and bought a house for $800,000, you cannot do this process. Another issue in this is that neither party can get spousal support. So both people have to agree no one wants spousal support, and everyone has to sign an agreement that divides the property, including cars and debts. So if this sounds like you meet all these requirements, then you can file for summary dissolution. To do this, basically, it's a joint petition. Both parties sign, submit it, and once the judge reads it and processes it, then the parties are divorced. And if you have any questions about summary dissolution, we have represented people for this. You can always call us at 626-898-7200 here at Barsana Law. And again, I am attorney Noreen Barsana. Thank you so much.